You have the floor, sir.
Thank you very much. Good morning, ladies and gentlemen. I'm sorry, I don't know if it works. Hello?
Yes.
Yes, it works. Well, hello, good morning, ladies and gentlemen. My name is Javier Torres. I'm a state attorney. I have been working in investment arbitration during 3 years, defending Spain against all the investment arbitration cases regarding energy, but also regarding mining or regarding agreements reached by the Kingdom of Spain. Our experience is deep in this world, and now is a fascinating moment because after Acma Judgment is changing the concept of the investment arbitration in the whole Europe. You have to think that these are very, very expensive cases, 6 million euros, 9 million euros, 11 million euros fees each case. It's a lot of money, so it's a business for some legal firms, and they try to promote such cases, but the European Union is threatened because of the behavior of some arbitrators, which are not.
Si se pone aquí es más fácil, quizá.
I'm sorry. Okay.
I think it's easier for you.
Yeah. Okay. Don't worry. Thank you very much.
Yeah, thanks.
The behavior of some arbitrators which are not applying the European Union law has provoked that the European Union in Achmea, in Micula, and now in some Spanish cases, because Spain won the first 3 cases, Las Rozas, an ICSID case, and Stockholm Commerce Chamber case, Charan, Isolux, were won by Spain, but then we have lost Acer, Mazda, Nova Energia. So the European Union is trying to defend the European Union law. But also we have that ICSID is modifying the convention, and also UNCITRAL is modifying their convention, because you know that the European Union has reached an agreement with Canada, the Ceta agreement, which states a permanent court. And UNCITRAL is trying to move in order to achieve such character, in order to develop such cases. But also we have NAFTA treaty reached between United States and Mexico, which has taken out from the dispute solution measures ICSID convention. Now between United States and Mexico, they won't apply in the future ICSID convention. So we are in a challenging moment where the investment arbitration will have a much more future than before, as we have here before. Yes, it's true that it is the future, but in a different approach, in order to protect the regulation right of the states, and also some regulations as the European Union law. Well, I would like to highlight that European Union has said ICSID is dead. I think it's so strong words. Please, a glass, if it's possible. So strong words, but it shows to the world that the approach of the ICSID tribunals is not admissible for some international organizations. Well, regarding the European Union law, I think that which is important, the consideration or not of the European Union law as international law, because it has to be applied by the arbitral tribunals. So you have here Article 42 of the ICSID Convention, or also Article 26 of ECT, Energy Charter Treaty, which states the applicability of the international law. And you have many scholars that try to convince arbitrators that the European Union law is a regional law faced to international law, as it was, or it were, a category different and contrary to the international law. Well, in fact, the definition of international law is achieved by the European Union law. You have the Statute of the International Court of Justice, Article 38, which states that international conventions are those which states' rules expressly recognized by the contesting states. Well, the rules of the European Union are recognized by the states of the European Union. So I think it's not difficult to understand that it's a genuine international law. You have also many arbitral tribunals who has stated clearly that the European Union law is an international law. I would like to highlight the reasoning of Blossom Award is recent, which state that any kind of EU law, it's international law, is part of the international law, and so it has to be applied when it's relevant. We have also a kind of rules, it's state aid rules. It's an issue very important in the European Union law, which also is applicable to the legitimate expectations of any investor in European Union, because those rules will be applied even without the aim of the state, of the member state, to apply such rules, because they will be applied by the European Union, especially by the Commission, which will keep under constant review all systems of aid existing in those states. So the relevance of the European Union law is not only as international law, but also as domestic law, as national law, because it has to be applied by the member states and also will be bound and applied and enforced by the European Commission. And it has a specific affection to the legitimate expectations of any investor. I would like to go very briefly regarding the Court Justice European Union role according to the Treaty of Functioning of the European Union in order to explain Achmea Judgment. Okay. The Treaty of Functioning states that the Court of Justice shall ensure the full, and it's important this word, the full applicability of the European Union law, and also its interpretation, its binding for the European Union member states. And it states in Article 267 of the Treaty of Functioning that the Court of Justice shall have jurisdiction, is the exclusive jurisdictions of the Court of Justice stated in an international treaty, international law. Wait a second, please. Well, now we move on to slide 7, please. In slide 7, if you have in hard copy, you can see the Acmea Judgment, the ruling of Acmea Judgment. Many scholars says that this judgment, which was rendered by the Court of Justice regarding the Acmea case, is referred to a bilateral investment treaty, and it's only applicable to other bilateral treaties because they highlight the mention of Article 8 of the agreement between Netherlands and Czech and Slovak Federative Republic. But this ruling mentions this article as an example, and I have highlighted the wording such as. It is an example which is mentioned in the ruling, but I would like to read the ruling without that example. And if you read with me, please, in the box, down the slide, you have the real ruling of the Court of Justice, which will be case law. Such articles 267 and 344 of the Treaty of Functioning must be interpreted as precluding a provision in an international agreement. It says international. It not says bilateral. It says international agreement. And it continues saying concluded between member states. It does not say between two member states. So the ruling is general. Many scholars say that no, because it mentions an example. But in my opinion, it's a general rule which will be applicable in the future for international agreements concluded between member states with no mention of a number. And in these cases, when it refers to an arbitral tribunal, it's contrary to the European Union law because it's not allowed to apply the full interpretation of the European Union law. It's the conclusion of the 28 judges of the Court of Justice of the European Union. Well, we move on to the following slide. We are going to see now the grounds of the Achmea case, very briefly. First, these grounds are not formalistic, but substantive. It examines the nature and the characteristics of the arbitral jurisdiction, and it refers to international agreements. And it also states, once again, the primacy of the European Union law, because the European member states decided in Treaty of Functioning of European Union, 2008, that the European Union law would be applied with primacy facing to other laws. Well, but it is developed. Why Acma Judgment conclude that ruling? Well, it invokes the prior case law. And this case law was rendered regarding multilateral treaties signed by the European Union. This is very important because the Spanish cases, the ECT cases, we are talking about a multilateral treaty signed by the European Union and the member states in 1994. Why? Because the competence to sign such treaties was shared by the member states and by the European Union. Now, in 2008, after Treaty of Functioning, such treaties are competence of the European Union, so could be signed by the European Union only. But in 1994, had to be signed by both EU members and also the European Union. Well, but we have first the opinion 191 invoked by Acma Judgment, which was rendered in 1991 regarding the European Economic Area Treaty, which was signed by the European Union. And it said that the court stated in such treaty conflicted with the European Union law, and it had to be modified. We have also case C459/2003, European Union Commission versus Ireland. This is a very curious case regarding arbitrational matters because the United Nations Convention on the Law of the Sea stated an arbitrational court which could decide any dispute between states, parties of the treaty, and Ireland sued United Kingdom through an arbitral court. But the European Union Commission sued under the Court of Justice of the European Union, Ireland, because it used other procedure different than that such stated in the European Union law. Ireland said in that case before the Court of Justice that the United Nations Conventions on the Law of the Sea was signed by the European Union. So it was part of the European Union. And if such convention stated an arbitral tribunal, it implies that the European Union accepted such tribunal. So it was incorporated to the European Union law. But the Court of Justice said no, because when the European Union signed a multilateral treaty, it has no competence to modify the treaties of the European Union. So the modification has the limit to respect the internal European Union law. So since 2006, state that an arbitral tribunal resolution award would challenge the European Union law as it would not be applied completely. So it did not admit the awards of an arbitral court rendered under the United Nations Convention on the Law of the Sea. It was repeated regarding resolutions of the United Nations, cases 400 of 2005 and 415 of 2005, and also opinion 2/2013 repeated such reasonings regarding the European Convention for the protection of human rights and fundamental freedoms. So with this case law, we can develop the grounds of Achmea case, Achmea judgment. It states that any international agreement concluded by the European Union would form an integral part of the European Union law. Please, it is in slide 10, if you want to follow it. Such international agreements form part of the European Union law, but it cannot affect the allocation of powers fixed by the European Union treaties. But what happened with arbitration proceedings? Well, it also states that arbitration proceedings between member states is important, between member states. Stated in international agreements, nor can affect the allocation of powers fixed by the treaties, as the arbitral tribunals are not part of the judicial system of the member states. But it grounds in the judgment of Achmea. Well, it's not possible that any international convention can be applied because it would affect the European Union law. It's no, yes, it's possible. It's possible. An international convention only can affect the Court of Justice European Union powers if any, and I repeat, any action by the bodies given decision-making powers by said conventions do not bind the European Union and its institutions to a particular interpretation of the rules of the European Union law. Furthermore, solely this possibility makes incompatible an international treaty with European Union law. Well, this is the key issue of the ruling, and which is the innovation of Achmea. Achmea applies such case law, which was stated between member states, to the national of those member states when they sue under an investment dispute through an arbitral court another member state. This is the innovation of Achmea. Extend the case law of all these previous cases to the nationals of the European Union member state. This is developed through paragraphs 31 to 57 of the judgment, and only one paragraph, 58, refers to the bilateral nature of the treaty assessed in that case. Well, this is paragraph 58, the most cited paragraph by the scholars, which consider that Achmea judgment refers only to bilateral treaties, but they forget the previous paragraphs 31 to 57, which do not refer to the bilateral nature. Well, but Achmea states 3 prerequisites which will be applied in order to decide if any convention, any treaty, affects the European Union law and it conflicts the European Union law. These 3 requisites has to be fulfilled. Okay, the first one is whether the arbitral tribunal has to apply or interpret European Union law. Usually, in investment disputes, you have to assess issues related to free movement of capital, public subsidies, or freedom of establishment. So it will usually affect to European Union law. Secondly, whether the Court of Justice could exercise its powers. First, it could exercise its powers through a preliminary ruling, but arbitral tribunals cannot request a preliminary ruling according to the Treaty of Functioning of the European Union. And additionally, in other way, the ICSID Convention does not allow to review the awards rendered by an arbitral tribunal, so it's not possible to interpret the European Union law according to the Court of Justice because the award of the arbitral tribunal won't be revised in such grounds. I would like to highlight that the Convention of Washington obliged to enforce the awards as if it was an internal judgment. And this is contrary to Convention of New York, which allows to appeal the award in order to the protection of the public policy, the public order. And you can go through this ground in order to introduce the European Union law when you appeal against the execution, the enforcement of an award under a New York Convention. That's why the European Union is not so afraid regarding UNCITRAL awards, because the UNCITRAL awards will be enforced under a New York Convention, which allows to consider the European Union law through the public order. But the annulment of an ICSID award is very difficult. There are formal grounds and very difficult to be admitted. Well, I would like now, finally, to highlight the case law application of two intra-EU disputes under a multilateral treaty. First, I would like to throw to the public one question. The scholars are making this question publicly in investment arbitration forum. It's what would have happened if arbitral tribunals had acknowledged and applied European Union law as international law and had not granted damages in favor of investors in violation of the European Union law and the express warnings of the European Commission. We have Achmea case, Mikula case, Acer, Mazda, Nova Energia cases. Well, some scholars says that perhaps the persistence or perhaps the arrogance of some arbitral tribunals to ignore European Union law and the preeminence of the Court of Justice as the principal pillars of the European Union is what has provoked Achmea, and may actually be causing further detriment to investment arbitration. You know that the European Union is trying to change its treaties to protect investments. They have reached an agreement with Canada, with Singapore, Vietnam. They are discussing with South American country in order to state a permanent tribunal which could review the awards of the arbitral tribunals, considering, of course, the European Union law. I will speak later regarding an opinion 1/17, which will be afforded by the Court of Justice regarding Ceta treaty with Canada, which states specifically this permanent tribunal. I will speak later about it. In this moment, the international law allows the arbitral tribunals to apply the European Union law and to apply the Treaty of Functioning of the European Union, even to multilateral treaties previous to the Treaty of Functioning of the European Union. Why? You have Article 41 of Vienna Convention regarding the law of the treaties, which allows that a treaty, I will read, is better, two or more of the parties to a multilateral treaty may modify the treaty as between themselves alone if letter B does not relate to a provision derivation from which is incompatible with the effective execution of the object and the purpose of the treaty as a whole. So, the requirement is, letter B, the modification is not prohibited by the treaty. For example, ICT, Energy Charter Treaty, does not prohibit any further agreement between member states, is not prohibited, and does not affect to the effective execution of the object or purpose. It refers to the merits, but not to the procedural rules of the ECT. So the conclusion, in my opinion, is that through 2008 Treaty of Functioning, member states not only decided, not only could decide, but also decided to modify procedural rules stated on previous multilateral treaties as ECT between only member states and their nationals. This is international law which allows such modification. But we have also that the European Union Commission, the guardian of the treaties, is applying such case law that I have been explaining before, prior to Achmea case, prior to Acma Judgment. So you have the decision of 2017, you have also a decision of 2016 regarding Czech Republic, which applies this case law specifically to the ECT. And we have the answer, which will be rendered soon by the Court of Justice of the European Union, because I have said the Court of Justice has been requested on opinion 1/17 to provide an opinion regarding the Ceta treaty. You know that in June 2018, all the member states were here, the arguments were here, and the decision was expected to be rendered on December 2018, in 2 months. But the Advocate General was expected to issue his opinion on 23rd of October, that is 2 days before. And now it has been postponed to January 2019. It seems that it has difficulties. It's not an easy issue for the Advocate General because it issued an opinion contrary to Achmea case. So I think that he's studying deeply this case. And I think that is important, this opinion, because it will face with a deep issue regarding international law. It has to be respected, the primacy of the European Union law, and even more, it will survive the European state aid rules. Why I say this? Because if you allow that an arbitration tribunal states that a state has to pay to another, a national of another member state, an amount of money, even against the rules of state aid, it implies that any state can pass through such rules only giving such money to a national of other member state, because they can go to an arbitral court which will decide that the state has to pay, and the European Union could not do anything. I repeat the idea, it could be a fraud. If Spain wants to give state aid, for example, to a media holding as Prisa or A3 Media, if they want to give money against the rules of state aid, distorting the market, they could give money to a subsidiary of Prisa, for example, with seat in Luxembourg, and when the European Union comes over Spain in order to modify such decision, the enterprise could sue Spain through an international arbitration court in order to be condemned and in order to pay such money. So the rules of state aid at the end of the day wouldn't be applied. So they are very important. It's a very important matter for the European Union, and I think that reasonably they will follow the case law stated before. Is the reasonable idea. So I have no more to say. Thank you very much for your, and I have not said before that I am very pleased. Thank you for Cremades&Calvo-Sotelo for inviting me in order to share with you such matter, because I think it's a very, very important moment in investment arbitration, and we are living a very, very challenging moment in order to solve such problems, not only in Europe but also in United States and a lot of countries.
Thank you very much. You.